parastatal in the country or anywhere in the world. Okay, let's limit to Nigeria. That would say that they have enough funds to prosecute what they have to do. I mean, the army would complain, the MDAs would complain, and the likes, right? So I think it's only the legislature that maybe the executive too that have some, enough to satisfy what they have to do, really. But then when it comes to judiciary, and thanks to the incumbent president, Mohamed Buhari, when he signed the bill into law, that is the judicial autonomy,
yes.
I think a couple of months ago or thereabouts. So the idea is now to make funds flow. Funds accruable to the state judiciaries will flow directly, from the federal government account, straight to the coffers, and under the care of the head of the judiciary, that's the CG of the state, like that. So that would, in my view, I think, aid things, make things better. We're waiting for local government autonomy. All right, so we have manpower shortages. At the time I was having a matter in Lagos like that, I think a brochure or thereabout, and I saw the cost list for that day. Cost lists are the list of cases that a judge, a court has to go through in a day. I saw about 42 or thereabout. So imagine one judge hearing 42 different cases in a single day. There is no way the health of that judge is going to be all right. There is simply no way that's going to happen, really. So that seemed to be a major thing. If, for example, they had more courts in that state, it's a simple mathematics or arithmetic. It's a matter of taking off some cases off the docket of that court and shelving them on, the other courts created. All right. So that's external, really. Other ones are specialized court systems. We have election petition tribunal, for example, that are constituted after elections are being held. All right. So we have, in some states like Lagos, we have sexual offender special courts as well. All right, so we have customary courts that deal with customs like that. So if you can have more specialized courts like that, I think it will help. That's also external because there has to be a law creating them. Another one is the NICN, what we call the National Industrial Court of Nigeria. What they do basically is employment and labor matters. So when you have complaints about you've been sacked, you've not been promoted, you have been owed salary gratuities and the likes, where you go, you can't go to any other court in Nigeria except the Industrial Court of Nigeria. So we have courts that have such, specialized system. We call them original jurisdiction. So that's external. Laws have to create them. All right. The internal one I see, which I know of a surety will go a very long way, are things like, as I speak to you, Toby, some judges will still tell you that they don't want to do virtual hearing, but big kudos and thumbs up to those that are doing it already. I've done some in Ogun State. This year alone, I think I did about 1 or 2 virtual hearings. I was right in my office or my house, I can't recall. The judge was in his chambers, all right? The registrar that will swear a witness on oath was right behind my lord. They were together in the office of my lord. I think I was either in my house or my office, I can't recall. I was robed. I had my wig and gown and everything on like that. I was robed. The other lawyer from Ilaro, all right, Barrister Beke, also was, I think, in his office. His junior was right beside him. He announced his appearance, I announced mine, like a normal court sitting would have. To be, Zoom has about 40 minutes free meeting time. We were able to finish everything. It was a matrimonial causes matter. It was so seamless, all right? Of course, we had little, networking glitches, yeah. But we have glitches in court anyway, too. Someone can walk in with cocoa caca of a shoe like that and the likes. So, but it's a way to go. I think it was so easy. I even tendered an exhibit online, all right? Time wouldn't permit me to go into what happened. So I think that one is not external. The court can by themselves agree to do that.
To reform itself.
Exactly. Another thing is, there are some very no-course applications that you still see on court dockets or court lists. One of them is, application to serve by substituted means. What that means is, I want to serve you as a defendant, and I've not seen you in person. The law says, I think by Order 7, Rule 5, thereabout, that Rule 1, beginning, that you must serve a defendant in person. But in the event where that's impossible or proves difficult, law permits you to, by Order 39, bring a rule, application for substitute service. That is, you would serve that person by any other means. It could be by electronic means, by mail, by pacing, etc. All right. That kind of application is so innocuous because it's going to be granted anyways once you have shown that you have attempted to serve and you have not been successful. That kind of application, in my view, ought not to be on the court list at all. It can even be heard, in my view, by DCR legal. What that means is someone that is not really a judge, strictly speaking, but works as the head of legal department. So these are things that, I think judiciary can look into to make work. Another one, and I will stop on that, is the issue of what we call CMC, or in Ogun State, we call it PTC, Petroleum Conference. I mentioned NIC and then Industrial Court of Nigeria. There's also the Federal High Court. In these two courts I mentioned, we don't have what we call Petroleum Conference. In a Petroleum Conference, what you do basically is just to look at preliminary matters, before the trial will start. By rules, it takes about 3 months to happen. Now, that for me wastes a lot of time, because even things agreed at a PTC can still be changed, whether issues for determination, whether number of witnesses you are calling, exhibit to attend, they can still be changed even by the law anyway. So in industrial court, for example, or federal court, once you file the writ of summons and you get a date, the next thing is straight to hearing, no PTC. They are still courts anyway, and we still get justice. So things like that, I think, ought to be taken off so that the judges can have better health system, even for lawyers, and speedier justice. So these are things I think. All right,
I'm going to take you over on a couple of things that you mentioned, but let's quickly engage the Senior Advocate of Nigeria joining us on the roundtable this morning, Barrister Yinka Kutoye. Thank you for joining us. Good morning. Good morning, sir. We can hear you. I think you need to. Okay. I can hear you too now. Thank you for joining us. All right. Yes. So, as we were saying, are you with me?
Yes, please.
Okay. All right. So we were looking into the issues of the role of the judiciary in the sustenance of Nigeria's democracy, and making sure that the people do not give up on our democracy, and of course keeping hope alive. What exactly are your thoughts on these?
Well, once again, good morning. I've had the privilege of listening to my colleague who had spoken earlier. And from the bits that I heard, I think we are both adding them on what needs to be done. But before I go into that, I am of the view that the judiciary as it is still holds the hope of the common man. Because as I'd always said severally, if we destroy the judiciary, it will be a ready recipe for chaos and anarchy. And I'm not sure any one of us will be ready for such situation. As it is now, the judiciary is an important arm of our democratic process. And that is why I will advise that once we submit our dispute to the court, we should learn to take it out of the street and allow the court to do its work. Secondly, we should also realize that the court consists of human beings, manned and run by human beings like you and I. They are susceptible to their own prejudices. They are vulnerable to several attacks and blackmail. If we go on that trail, we will not get the best out of them. So for me, we should allow the courts to do its work. Let the judges do their work in good conscience, free of any intimidation or blackmail, and we'll see the best of the situation.
Your colleague, Kyle, mentioned earlier that there is a shortage of manpower in our courts. I wanted to take him up on that because I know that there are so many lawyers, members of the bar. What I think is a challenge, which I've also heard a couple of judges mention, is shortage of judges. And that's why too many cases are on the table of some of our judges in Nigeria. Why do we have so many of you who are lawyers, experienced, brilliant, vibrant lawyers who are not willing to become judges?
I can see that you are also laughing.
Yes.
That's a very tricky question.
Because I know it's a turn in the
But you see, the shortage of manpower is not limited to judges alone.
Okay.
I had my learned friend discussing about the use of technology.
Yes.
In judicial proceedings. You will be shocked to know that we don't actually have sufficient IT personnel inside the courts. We don't have sufficient court recorders. Most of the judges still write longhand. We don't have sufficient transcribers. We don't have sufficient research assistants. So, all this taken together affects and or impacts negatively or otherwise on the performance of the judge. So as it is, unless the judiciary is made to be independent, unless they are allowed to run their own affairs, we will still continue to have such shortages.
Okay, I will still take you up on that. Wait a minute. Let's go on this short break. When we come back, we'll continue with our discussion. Just stay with us, Bazai Kakutoye. All right, welcome back. It's still the roundtable on OGTV, the People's Telly. We are discussing Nigeria's democracy and the role of the judiciary. And the discussion is actually dovetailing into the challenges of the Nigeria's judiciary and what they must do to evolve and, of course, be better in the dispensation of justice. Joining us via Zoom is a senior advocate of Nigeria, Yinka Kotoye, and of course we have Kaudi Adoremi, a legal practitioner here in Ogun State, right here in the studio. Before we enter that short break, my learned son, we were talking about the shortage of manpower in the judiciary, and you talked about IT personnel and some other essential staff of the court. So my question, however, still remains, why we do not have many of our lawyers aspiring to be judges. If I were to ask you directly now whether you are interested in becoming a judge, I'm sure you have something to say. If I ask Mr. Kadademi, why are you not interested in becoming a judge? Many of you will have something. So I want you to be very explicit as regards this.
You see, we need to make that job more exciting and more attractive to legal practitioners.
Okay.
For instance, once you become a judge, you can no longer take up private practice, even if you are dismissed the next day. So in these days of economic crisis, and with this our perilous situation, we would rather risk the certain for the uncertain. Then we also have to look at the remuneration of the judges. It's not motivating enough. You have judges who are not supposed to do any other thing apart from concentrate on the work they do in courts and the work they do in chambers and the work they do at home. Most of them don't have any social life. They hardly have a social life. Most of them have responsibilities to their families, both immediate and extended. And you are not paying them commensurate enough to make them concentrate on their job. You won't attract the best hands. Leave me out of it. My own lifestyle does not fit to become a judge. I can't, as a person, I'm just too restless to sit at a particular place at a particular time. And I don't have that temperament. Sincerely, between you and I just don't have that temperament. So I have never even crossed my mind, even as a law student, that one day I will end up on the bench. But beyond that, I know of so many brilliant, hardworking, and decent, diligent counsel who would have loved to go to the bench. But when they consider the uncertainty, the poor remuneration, vis-a-vis the volume of work, it will be a negative motivation for them. How could you explain a judge or a court having 15, 17, 20 cases on its docket in a day? We are human beings like you and I. I know that there are some situations where some of them are not particularly tidy in the way they arrange their courts. But at the same time, we need to be fair to them. The volume of work is overwhelming. The volume of work is overwhelming. And it will be so because of the way we have structured our judiciary. I mentioned this sometimes, maybe in one of your programs, that we run a quasi-unitary judicial system. We run a quasi-unitary judicial system. As it is, everything is centered. If anything happened in my village in Eric, local government, to get to Abeokuta, you have to go all the way, the appeal routes, all the way to Abuja. We need to decentralize the system. We need to decentralize the structure. By now, I don't see why we shouldn't have state appellate system. In a federation, the component states should be entitled to have their own judicial structure. Everything does not have to end in Abuja. By now, I don't see why we should not have Ogun State Court of Appeal. Before, in the First Republic, we had the Western Region Court of Appeal. We have the Western Region Supreme Court. I see why you shouldn't be able to go back to that. If there are states that cannot afford to run an appellate system, they can join with neighboring states. I see no reason where cases bordering on chieftaincy title of rebellion in my village, we end up in Abuja to be decided by someone appointed from Benin Kebbi. What is he going to say, or what will he know about the customary law of my poor village? See, those are issues that still surround our judicial system that we all need to look into, and that needs to be addressed as much as possible. And I think, as it is, the incoming administration should also look at it, both at the federal and at the state level. Each one of them should look at how do we unbundle, that's the word I've been using, how do we unbundle the courts so as to ensure effective judicial process. Because, like I said earlier, it is about the only hope that the common man has. That's about the only hope. There is no denying that part. Either you are doing commercial transaction, you are doing land dispute, you are doing chieftaincy dispute, you are involved in criminal matters, you are involved in social issues. Disputes arising from them ought to be submitted to court. Otherwise, we will get to that probation level where people will just be taking up arms against each other. And I don't think that happens. So we have to look at those critical areas that hinders or that is hampering the effective administration of justice as a whole, and then address it. And one of the component parties, the structure of the court, our court structure as it is. We need the quasi-unitary nature. Let's have a more federal structure in the courts, and let's see how things will run.
Okay, I'll come back to you because you've dragged us into my next phase of interrogation in quotes, and that is why we need to set agenda for the judiciary in this new dispensation. I want you to, he has started it, talking about unbundling the courts, decentralization, and those very germane issues he has raised. Would you begin to, by scale of preference, itemize your agenda for the judiciary in this new dispensation?
You see, when you sent the topic to me, Toby, I told myself, I was just trying to brush through some relevant things I've gathered from experience, and then from available materials. And I told myself that judiciary agenda has been set. In fact, before judiciary was created, there is a law establishing the judiciary system. We have chapters 1 to 8 of Constitution, chapter 1, general provisions. We have 2, fundamental principles of state policy, 3 talks about citizenship, 4, human rights, 5, executive, legislature, 6, executive, and 7, judiciary. So if you read that part, it already talks about what their agenda is, as explicit as possible, really. Basically, it is to dispense justice. As my learned senior has said, it's like the hope of a common man. That's the agenda, QED, where you seek justice, as he has said, whether family matters, commercial, whatever it is, it ends in the court. Even look at KAMA, for example. That's the Companies and Allied Matters Act. After it was enacted, some certain provisions tend to kind of circumvent rights to freedom of association. Some lawyers went to court. All right. So despite that, all the lawmakers at the 2 strata, the National Assembly, House of Rep, and Senate, came together, and the president assented to it. A lawyer went to court and said, I think this is not right. And the court sat and agreed. How so? Because those particular sections that were struck off tend to offend, the Constitution as presently constituted, all right? So that's what the courts are there for, really. Every party would come, you have done your own, okay, fine, I've done my own, fine. Come together to court, let's hear your part again, and look, side by side, you juxtapose with what the extant laws say. So absolutely, the agenda is set. And there was a time I was engaging the Speaker of Ogun State. I've said this over and again. I think at times he watches our program. And I confronted him at a point. I asked him that, sir, after your 4-year term as the Speaker, or even as a floor member at the House of Assembly of a state, how can we tell whether you have done well or not? The truth is, I have not gotten, what I would call a satisfactory response. It's difficult to tell. If I ask you to be as versed as you are, as I almost say politician, as a journalist, a broadcast journalist and the likes, what are the KPIs that the president-elect, the new one, has set? It's difficult to pinpoint. It was even better in 2015 when President Buhari was saying that, for example, he would relocate, the army headquarters to Sambisa Forest, 3 million jobs to be gotten. Those were KPIs. We could measure success, and that's why when those things were now achieved, there were some issues in 2019 when I was seeking to be re-elected. All right, but now I think the president-elect was, I don't know, for lack of better word, smart about it. There were no particular things he said, apart from the fact that corpers will become soldiers, they will join them and the likes, and we eat a lot of corn, agbado and the likes, but that was on a lighter note. But we did not find so much KPIs to measure with. Same thing with the legislature. So we had the executive and legislature not having clear cuts, broadly known and accepted things we can look at as citizens to say, oh, you have done well, or you have not done well. There are nothing of such. It is not same for the judiciary. All right? And even if anything, it ought to be the reverse, because a lot of money is spent to bring in the executive and judiciary. I think over 300 billion naira or so was earmarked and spent for this past election. Think about that. To bring a judge in, I don't think it's paying up to $1 million. I'm not saying about salary. I mean to bring them in. There is no even election, it's appointment. All right? Despite that, judges still have KPIs. For example, quarterly, every judge, everyone on the bench, whether magistracy or as a judge, whether as measured as a judge, you give what you call quarterly returns. That's about 5 cases, contested cases. You must report to the NJC. So by that, your progress or success or diligence can be measured, because there are yardsticks.
Can be scrutinized.
Exactly. We don't have saying. If President Tinubu, once after being sworn in, spends 1 year, how can we say, for example, what I have told you now is it's a regulation, all right? There is a document you can read and see what I've said there. We don't have the same like that.
For the executive
and the legislature. The judiciary is not so. So what happens if, for example, a judge or a magistrate fails to make, returns for 5 contested cases? A query can be issued. So there are people there to question you. Why is this happening? Is it that you don't have enough cases assigned to you? Were you sick? Were you ill or something? So we see that they are on their toes already. So we have agendas clearly cut and set out for the judiciary already. It's a simple thing, all right? So how they dispense justice is a different ballgame entirely, right? But talking about agenda, it is overstated, and I've cited examples of why I said so.
Okay, now I mentioned earlier this endless debate about the separation of the office of the Minister of Justice and that of the Attorney General of the Federation. What is your take on that?
Well, I thought we were going to say that Minister of Justice and commissioner.
No, I'm talking about federal level. The Attorney General of the Federation. Yes. And so what the current arrangement we have now, one person does the job of the two. One person is appointed into the 2 positions. And people have said you need to separate the 2 so that the Attorney General of the Federation actually works for the federal government, or the president appoints him, and then there is a Minister of Justice that would actually man the Justice Ministry, and those 2 should be separated. That endless debate continues. So what's your own take on that?
Well, I agree entirely.
Do you even think that hampers delivery?
Yes, it does hamper it. There was a time I was on the same platform with the former Attorney General of the Federation. And then I asked him a question. I decided to make it an open comment. Something like, we have seen ministers of justice defending political parties. That ought not to be so. As a minister, you can defend your political party. It's an appointment to serve whoever appointed you. There's a difference. As Attorney General of the Federation, you are appointed to serve the nation. Your allegiance is to the country. What that means is, if need be, for you to utter statements that would make you at, for lack of better word to use, loggerheads with you know, the appointor, yeah, you say that as you know, pointedly as possible, as respectfully as possible. That's what is expected, you know. But when you have a merger of the two, we have a lot of overlaps. We have seen that in some states too, all right? I have seen a particular situation whereby a particular political party was fingered as doing some things wrongly. And the Attorney General of that state came out and issued a public statement, all right, trying to defend or launder the image of the party. That is wrong on all fours, all right? Not even the governor should do that for, really. Your allegiance as a commissioner for justice or minister of justice is to the state and the constitution, period. But as a minister, you know, sorry, your allegiance as attorney general, yes, of the state of federation is to the state and constitution, right? Not the president, not the governor that appointed you. But as commissioner for justice and minister of justice, of course, just like any other minister, your allegiance is when they appointed you. So there ought to be a separation. Look at the permanent secretaries, for example. They are not directly having allegiance, for instance, you know, to the governors, all right? Are they not appointed? Yes, they are too. The allegiance is first to the state. In fact, first and last to the state. The best interest of their ministries and the state. So, you know, to that extent, I believe firmly, especially in a case like Nigeria, you know, that ought not to happen. If you backtrack to like 8 years ago, it is difficult to read one thing, for example, that the President Buhari has said, and that AGF Malami came out to, whether tacitly or publicly disagreed on. There was one that was, you know, blatantly wrong. That was when the president attended the AGC of lawyers, you know, General Conference of Lawyers. And one of the things he said is that national security will override or be superimposed over rule of law. There is no way in the world except where there is war. You know, even in war, we have rules, all right? Where that happens. So I expected the AGF, for example, as a general federation, to come out and say,
and correct,
exactly,
Mr. President,
because he's the first law officer of the whole federation. All right. What we saw, unfortunately, was he was trying to, you know, decorate or trying to quote what had been said. That's not right. But if that office had been separated, we might have seen that. So for these reasons, I think that a lot of allegiance to the country and the constitution has been mixed, you know, in a great deal, you know, with allegiance to whoever has appointed you. So to that extent, I think the two offices ought and should be separated.
Okay, let me go back to our senior advocates. Sir.
Yes.
Are you with us? Yes. So,
yes, I'm with you.
Yes. Leonard has talked about a couple of things as regards agenda setting and, of course, separation of the Minister of Justice and, of course, the Attorney General of the Federation. I want you to quickly comment on this, but most importantly, I want you to tell us how the judiciary can actually change this battered image of itself. There is a perception problem or a perception management problem of the judiciary. People even don't talk about the corruption, mostly in the executive arm of government, even the legislative arm of government. What is always on the lips of average Nigerians is that, the judiciary is corrupt. The judiciary is very corrupt. The judiciary is very corrupt. That is a perception that is out there, and it's a perception management problem if PR practitioners will look at it. So how will you, the judiciary, work on that as we move forward so that the people will not say, oh, forget the courts, you will never get justice?
Okay, before I go into that, about separating the office of the AG from that of the minister sex.
Yes.
I am. Hello?
Yes, I'm with you. Yes, I'm with you.
Okay. I wanted to say that We have had such an arrangement before in 1983, after the 1983 general election. And late Kehinde Sofola was appointed as the Minister of Justice. That office was separated from that of the AG. Unfortunately, we didn't enjoy the benefits because of the Buhari coup of 1983.
Yes.
So, if the act of office is separated, you have a situation where the AG will become less political. The minister will be a political appointee. The AG will be a professional. And like Mr. Gaderebi said, he will be able to correct the president of the government as it might be, and I think it's the president in this instance. He will be able to correct the president, even the governor, yes, as it might be, where they had erred on the points of law. I was at that AGF in Abuja where outgoing President Buhari categorically said security issues will override human rights issues and the rule of law will not have no place. I was there, I heard it live and direct. It's not as if somebody told me. And I shrank where I sat on that day. In fact, I actually wanted to raise a question in that hall, save for the fact of the presence of heavy security men and the fact that some of my colleagues will think some of us are irascible and want to disrupt the government. But I think that was a careless statement coming from His Excellency. I think it was uncalled for. But nonetheless, if we separate that office, we will see a situation where the AG will be less political, the AG will be more professional, and then it will have a direct impact on the administration of justice. That's the major point. Yes. Because you will now see an AG who will be very professional, who will look at things the way the law should be, address issues the way it should be addressed, and take a decision strictly based on what the law says. Whether you agree with him or not during the political session is a different ballgame entirely. Now, according to the perception, I've addressed this severally and in one of my previous engagements with you. I do not and I will not agree to that general view that the judiciary is corrupt. I won't sit here and allow people to continue to say that.
Yes. And
I'll put it to you this way. You journalists also have bad elements amongst you. You have the brown envelope syndrome.
Yes.
Would it now be sufficient for us to conclude that all journalists are corrupt? Or that the broadcast, that the media, okay, let me use the media as the generate term, that the media is corrupt? No. There are still fine gentlemen like you that I will easily relate and defer to on any issue. Not that I'm flattering you. Very few people can get on a live program like this these days. Like, you are an exception. That does not foreclose the fact that there are some horrible elements amongst you in the media who just do anywhere they let follow. It's the same thing with the judiciary. The judges are appointed from the society. Yes, there will be infractions, I agree. There will be people, there will be some who, particularly for some reasons or another, are not living up to expectations or they are delayed or sidestepped. But that doesn't give a sufficient reason to now tie everybody within that sector as corrupt. Otherwise, I am also corrupt. That's what we are saying, that's the implication. And we should all realize that out of the three arms of government, it is only the judiciary that has a self-regulatory mechanism. It is only the judiciary that has a disciplinary procedure to discipline its members. The executive arm does not have, the legislative arm does not have. And they all get away with all forms of impunity. So I will now say they are better off, or they are higher, they are on a higher pedestal than the ordinary judge who is doing his work, his or her work, and then because of some fellow infraction somewhere, you are now saying that judge is also corrupt. Then what you also get away from the mindset that if you go to court, you are not likely to get justice. No, I disagree. In most cases, judges will decide what is presented to them. They are not gods, they are not angels. They have bloods running through their veins, like you and I. Now, when you have a colleague or a counsel or a party, because the litigant can also do his case by himself. When you have a party who comes to court, not well prepared, doesn't know where his case lies, doesn't know the strength of his case, does not know where the law that supports his case, does not know how to argue his case or present his case before the judge, how do you expect the judge to assist such a person? Let me use the pending Osun case as an example. When the judgment, some party will reveal that, oh yes, the judgment was the best. Some will reveal that the tribunal people have been compromised. Those that lost took that position. But they got to the Court of Appeal, they so lost at the tribunal, one at the Court of Appeal, and they believe that the judiciary is the best. Meanwhile, those who won at the tribunal, lost at the Court of Appeal, and they started gnashing teeth and made the judges scapegoats. So we should get away from this mindset and allow those judges to do their work unfettered. Yes, like I said, there will be cases of infraction, there will be cases of those who have not particularly lived up to expectation, there will be cases of those who believe that, yes, anywhere they left from the better. Once they are caught, I'm sure they are always dealt with. But to now generalize that idea and make it appear that even innocent people like you and I who just do our own way, do the hustle for our daily bread, are also part of that corruption. It's unfair. It's unfair to everybody. And that's my view on that one. Now, to settle an agenda, like my beloved friend said, the Constitution actually created the judiciary, and it has carved out its role as it is. That Constitution is. It is an agenda already. However, going further on to that, I will still urge the incoming administration to take a second look at the provisions of those Constitution. Like I said before, we need to unbundle the judiciary. In a federal system, bodies like AJC, FJSC, is, in my view, an anathema. If their functions are strictly limited to federal courts, or their jurisdiction and power is strictly limited to federal courts, I can understand. But when you now start relating or attempting to administer or regulate state courts, which also have coordinate powers, then you are operating a quasi-judicial system, a unitary judicial system, I'm sorry. Okay? When you now subject the process of appointment, promotion, discipline, and remuneration of state judges to a federal body, a body created by Constitution, set by the president, you are operating a quasi-judicial body.
And you want that to be duly addressed by the